Okay, so yeah, welcome everyone. My name is Donatas Murauskas. I'm assistant professor at Vilnius University law faculty, and this online meeting is part of the class protection of human rights in practice. And today we have a really specific topic and special guest. We will talk about rights of indigenous people in the United States. And we have a really special guest, Professor Grant Christensen from Stetson University College of Law, who is a well-known expert on federal Indian law. And Professor Christensen, thank you so much for accepting our invitation.
Well,
yeah.
Thank you. Happy to be here.
Yeah, and during our meeting, I will give a few questions, and we'll talk about more general questions, and then I think we will go to some more detailed questions related to the to some cases of the United States Supreme Court. And my maybe first more like broader question would be, why do we have this distinction, with like Native American people, civil rights, some other groups in the United States? Why do we have a special group of people and discussing it in this way? Because like usually, especially when we discuss civil rights or human rights topics in Europe, we discuss it taking like together, that this is kind of the rights that are for everyone. But in the United States, it's something, it's more about groups, different groups that have particular rights or doesn't have. Why is it so? Professor Christensen.
Yeah, thank you. Well, I mean, so obviously there are many differences between human rights in the US and in Europe, but in the area of indigenous peoples and why indigenous peoples get carved out with a different set of rights. And I think this is even true to some extent in Europe, although it applies only to like maybe the Samic peoples, the indigenous reindeer herding peoples of northern Scandinavia. That there is this kind of protection of indigeneity that crosses the boundary between a protection of a racial group and a protection of kind of an indigenous sovereign. So, unlike other groups in the US, right? So, of course, the way that our Constitution phrases rights like equal protection, it goes ahead and essentially is classifying individuals, right? That you can't be accounted for differently on the basis of your race. And so there are a group of persons, Hispanics or Asians or African Americans, or right. And there are these kind of large protections, gay persons, Black persons, women, right? I mean, we can group, we talk about group rights in that way. An extension of that in the context of our law here is the rights of indigenous people, right? There's this other kind of group, and it's very unique in that the rights of indigenous people are not the same as rights that we would afford to these other groups, right? Because we have to be, we have to be a little bit cognizant of things like equal protection. So we want to be sure that everyone ordinarily is treated equally, right? And that's one of those fundamental goals. And so we break people down, and although it is an individual right, we look at it in terms of, well, are you treating Asian persons differently than Black persons or white persons, or right, et cetera, et cetera. When it comes to indigenous people, though, indigeneity here isn't under the law treated as a racial group. It's treated from a rights perspective as a political sovereign. So almost the same way that you would say you can't discriminate on the basis of citizenship or nationhood, right? That Lithuania would have difficulty without some very clear reason discriminating only against Spanish persons, right? Or Canadians, for example, right? And because tribes are treated as an indigenous or as a sovereign, they're exempt from some of the racial scrutiny that the law applies, and instead are treated as this kind of political entity. And so that allows the government, in the context of group rights, to place group rights in front of individual rights in that sense, right? That the right of the indigenous government or the indigenous sovereign is protected in a way that the right of the individual is not.
you mentioned this political entity idea, and this might be the most, like, one of the most confusing and the most interesting matters. So about the sovereignty of Indian tribes, is it related somehow? And could you explain this concept of political sovereignty of the Indian tribes?
Sure. So when we say here that tribes are sovereign, we truly mean that they are independent governments. So the phrase the court uses is they are domestic dependent nations. And so it's sometimes a little bit difficult for persons, even American students who haven't spent time with indigenous populations. These are groups that have their own land base. They have their own court system, their own elected governments, a legislative and a judicial branch. Some of them have even other branches of government. And so they don't have to look like, our traditional kind of Western conception of government with three branches, one to, executive, legislative, judicial, one to make the law, one to enforce the law, one to interpret the law. Tribal governments can add branches or can merge branches together. And they really are, in that sense, sovereign, in that they make their own laws, and those laws are different than the laws of the rest of the country. And they're different in a sense that the Constitution of the US does not apply to the tribal governments. So if we think about our idea of incorporation of rights, like where do rights come from? So, in the US, we had our original 13 states, and they each agreed to give up some of their power to the Constitution, right? So they formed a federal government. So we had 13 original countries that made one country by giving up some of their power to the federal. And then as new states were added all the way up to 50, each new state ceded the same powers. So they agreed to be bound by not just the creation of the federal government in the US Constitution, but also all of the rights that are embedded in the Bill of Rights. Right. So they agreed to protect equal protection and due process and freedom of speech and the right to counsel and the right to a jury and, the right to bear arms. And right, we have some strange rights in our Constitution, right? I'm sure you guys are not unfamiliar. But in that sense, Indian tribal governments never gave up those rights, right? So they are sovereigns that never joined the constitutional compact. And because they didn't join the compact, they're not bound by it. So in some ways, indigenous groups or indigenous communities, the sovereigns, give greater rights to citizens within their boundaries. And in some ways, they give less rights. And that can depend tribe by tribe, community by community, sovereign by sovereign. There are 574 federally recognized tribes here, which the largest of which has more than 500,000 members. The largest reservation is bigger than Lithuania. So the Navajo Nation spans 3 US states, Arizona, New Mexico, Utah, right? And in size is larger than the nation of Lithuania and has its own complex court system. They have their own bar exam, right? You don't have to be a member of the US bar or attend a US law school in order to practice. You have to sit for the Navajo bar. And so in that way, that is a kind of sovereignty. And it's a lot of power. And we see that expressed in the case that you guys read for me today.
You served as a judge in some of the Indian tribes. You're currently serving as a judge. Could you tell us an example of how the cases are deliberated? How is it special? How it is specific from the way, for example, cases in state courts or federal courts are deliberated? Maybe some interesting examples.
Sure. So I've served on the Supreme Court of 3 different tribes here in the US and currently sit on the Supreme Court at the Fort Peck and Assiniboine Sioux tribes in Montana. And so our appellate court, we have a trial, we have 4 trial level judges and then 1 3-panel Supreme Court. So there's 3 of us that sit. And a lot of times decision making is probably not that different than the decision making that happens in state and federal court. But there are times where it is meaningfully and importantly different. So we've had a couple cases, maybe one that pertains to the right to inherit property. So where we have a male member who is no longer competent, right? You know, he's older and he needs a caregiver appointed. And both his daughter and his son have applied to be a caregiver. And by the measures or metrics that we would ordinarily use in a state court, the daughter is more likely to be a caregiver, to be the appropriate caregiver, right? She is more financially stable. She's located geographically closer to her father. He wouldn't have to move or relocate. She's willing and able to play that role of caregiver. But in Sioux cultural tradition, there is a male preference where sons take care of fathers and daughters take care of mothers. And in this cultural preference, which is embedded with a number of different kind of cultural attitudes, it would be culturally inappropriate for a daughter to see for a grown daughter to see her father naked, for example. And a caregiver, I mean, he's at a point where father needs care, personal care, right? And so even though daughter is in a better position, even though dad's life is going to be upended and is going to be disrupted in ways that are not in his best interest, according to Western standards, right? According to the standards that the state court would use. The court unanimously, like the trial court gave custody to the son instead of the daughter, and the appellate court unanimously affirmed on the basis of those cultural practices, even though admittedly that is a discrimination on the basis of gender. But it is a discrimination on the basis of gender in order to protect and uphold tribal culture. And when we sit on the Supreme Court of a tribal government, we don't sit to go ahead and impose Western values on the tribe. And I, as a judge, I'm not bound by US Supreme Court precedent on equal protection because I'm acting as an agent of my tribal sovereign and not as an agent of the state or an agent of the United States.
Mm. So it's very interesting. So how does is there a connection between the sovereignty of a tribe and Indian civil rights movement? Like how could those two like elements interact?
Yeah. Well, I mean, together and in tension at the same time, depending who you ask and what rights you're fighting for.
Yeah.
When you say like the Indian civil rights movement, the Indian civil rights movement here kind of started in the 70s with AIM, the American Indian Movement. And the rights that Native persons were claiming through that movement were typically protection from or by agents of either the state or the United States. They weren't fighting necessarily to force tribal governments to act differently. And yet right, because there is also this tension, right? This open discrimination against Native persons. And it is embedded even in our US Constitution. So depending on how much American constitutional history you and your students have, which I don't expect you to have very much, right? When we created the country, the original Constitution had within it the 3/5 clause that said that when we have to figure out, you know, if each state gets a number of representatives in Congress and the House of Representatives based on how many people live in the state. And so that immediately became a politically loaded question because, of course, at the time of the US's creation, we had slaves. And so although the Constitution doesn't mention slaves, it includes that a slave or persons indentured for a term of years will be counted as 3/5 of a person for determining how many people live in each state so that we get our representatives right. But there's another clause that even American students of the Constitution forget. In that same provision where we establish that a slave is 3/5 of a person, we have the phrase excluding Indians not taxed. At a time when a slave was 3/5 of a person, an indigenous person wasn't a person at all. And at the end of our Civil War in the 1860s, we got rid of the 3/5 provision, but we kept in the excluding Indians not tax language. And we have legislative history from the time that tells us members of Congress were willing to finally admit that slaves were persons who could vote and participate, but far be it for them to allow Indians to participate, right? And they made an intentional decision to continue to exclude Indians. So then we have a series of cases from the late 18 and early 1900s where Indians are denied, they can't be a plaintiff in a civil case. They can't be a witness because they aren't trusted, right? There's some kind of less than human, right? All the way up until 1924 with the Indian Citizenship Act, where we passed a law that made all Indian citizens. And it's so difficult to reconcile even with our own jurisdictional background, right? So the US is a nation that has birthright citizenship. Unlike Lithuania, if you are born here, regardless of who your parents are, you are a US citizen if you are born on US soil. And it doesn't matter if your parents have been here for 15 generations or 5 minutes, you are a US citizen if you are born on US soil, unless you're an Indian, because the 14th Amendment excluded Indians from the right to claim birthright citizenship. So our citizens who were here since time immemorial had to have Congress attach them their rights 60 years later, when all of the immigrants to the country obtained citizenship just by birth. So we have this long legacy, right, of discrimination on the basis of indigeneity. Felix Cohen, one of the authors of modern Indian law from in the 1940s, describes Indians as the miner's canary, right? It's what we allow to have happen to indigenous peoples. That's kind of that's what we will allow future generations to do, right? To other groups in American society.
Wow. That's interesting. And now, like when you talked about this special political sovereignty of Indian tribes, and there are many cases adjudicated at the Supreme Court that are related to Indian tribes' sovereignty. Would you?
Almost 5% of our Supreme Court's docket, an average of 3.7 cases a year since the 1940s. Yeah.
Would you consider that the rights of the Indian tribes are expanding, or it depends on the composition of a bench?
Yeah, composition, but and not in necessarily the ways that you would expect. And it depends on the issue that you're trying to obtain. So, for example, when it comes to like hunting and fishing rights, where even non-Indian people have this kind of stereotype of like the noble savage, right? Or the Indian out there, right? And so when it comes to these kind of rights, the court has been very expansive to protect kind of traditional culture. When it comes to Indians claiming more modern rights, the court has been a little bit more reticent. And it depends who they're claiming the rights from. Claiming the rights from a state versus claiming the rights from a tribe, right? The court has been more willing to allow tribes to discriminate against their own members because of the separate sovereignty. And we have, I mean, the cases really go in all directions. And so in 2020, we had this very important decision in my world, right? McGirt versus Oklahoma. And Justice Gorsuch writes for a 5-4 majority. And the case starts out at the end of the Trail of Tears, there was a promise. And so the Trail of Tears is the forced removal of Indians from the East Coast to the middle of the country. And it's this incredible protection of native land rights. In fact, he restores the entire city of Tulsa, a city of 700 and some thousand persons, to the Muskogee Creek Nation. So now all of a sudden, the city of Tulsa is on an Indian reservation. And that is incredibly protective of native rights. And then a year later, in Castro Huerta versus Oklahoma, we get a different set of 5-4 majority, recognizing that McGirt is good law, but allowing Oklahoma to impose more criminal sanctions against crimes involving Indians than had ever previously been allowed, overturning a case that was protective from 200 years ago. So it really goes in all directions. And the makeup of the court on Indian law cases is in some ways very different than you would expect if you understand the general, liberals are more protective of rights, conservatives are less protective of civil rights, at least, right? Or at least, I mean, we have to qualify that because, of course, gun rights are going to go the other way. But like, when it would come to things like equal protection or racial discrimination, and that's not true when it comes to Indian law. Justice Ginsburg was a champion of women's rights, but was not necessarily an ally of tribal sovereignty. Justice Gorsuch, right, who replaced Justice Scalia, is maybe the second most conservative member of the current court, but is a champion of the rights of indigenous peoples, and in part because he came from Colorado, where there were tribes, and where, as he was a judge growing up, as he was becoming a lawyer, he had to work regularly with these tribal governments, whereas Ginsburg spent all of her time in New England, where there are very few tribal governments, and had no experience interacting with them prior to coming to the bench. And so, right, it's a little bit difficult to predict Indian law cases based on the liberal or conservative attitudes of the justices.
Could it be also related to the fact that sometimes, what you protect, you're talking about the tribal rights, are some cultural, ancestral cultural tradition that might not be liberal in a modern sense. So it might be some reasoning why, for example, more conservative judge would be willing to kind of expand the rights of the tribe. Like, it's just a speculation. What would it be?
I don't think that we see that in our civil rights and our religious and cultural rights cases. In Indian law is so broad. So there are there are things that have nothing to do with rights, right? There are water rights cases and natural resources cases and federal government trust responsibility cases. But in the cases that we have, in fact, I think we see different members of the court using Indian law cases to advance other broader narratives. So if you don't have the right fact pattern to protect religion, like if you're a conservative like Scalia and you wanted to protect certain religious liberties, you might be more likely to get a liberal like Justice Sotomayor or Kagan, or formerly Justice Marshall or Justice Stevens or Justice Douglas, to join you if it was a more obscure religious case. So, right, one of, we have Bowen v. Roy is this case out of the 1980s, where an indigenous family objected to the imposition of a social security number, right? So essentially a national ID number, right, over their children. So the idea was that in Chippewa culture, names have incredible power to dictate both who you are and who you will become. And children aren't named until they are old enough to describe for themselves how they want to be thought of and what they want to be called. And so the imposition of a name, like a parent will not use a name for a child in traditional mid-Adawan culture, right? Because naming the child reduces or limits their future capacities under cultural traditions. So we get this Supreme Court case where the family wanted to qualify for certain benefits. They were poor, right? They otherwise met all the qualifications to receive some subsidized, medical care and a food allowance. But in order to do so, they needed to claim their child. And for their child to be claimed, it had to have a social security number. And the imposition of a number they claimed violated their religious beliefs. And so, in this case, we end up getting an opinion that is as much about protections of religious liberty as it is about an actual social security number or a child's name. As conservatives and liberals come together to draw, where are the limits? When can the government infringe on, right? Create decisions to infringe on the religious liberty of an individual that has nothing to do with the actual Midedawan culture or the naming of the child, right? Instead, the uniqueness of Indian tribes provide a vehicle for members of the court to talk to each other about other issues, right? Sometimes federalism issues, sometimes religious issues or cultural issues, the size or role of the government, right? And it's just, they provide these interesting fact patterns to get at other legal concepts.
So how did the case end? What was the outcome of it?
If you want the benefits, you do have to assign a number to the child. But that number does not have to be associated with a name. Like when I was born, I wasn't just given a number. My number had to be attached to my name at birth. You couldn't have a blank space. You couldn't have a number without a name identifier, right? And the court created an exception that you could register a number only without a name signifier if you had this cultural belief. And it was, right, so the conservatives said the government may not limit religious liberty, right? But everyone agreed that for record-keeping purposes, the number was a neutral was a neutral factor. And so was a non-religious right, and was necessary just for the government's record-keeping purposes. The child didn't even need to be made aware of the number, but the number needed to be kept for record-keeping purposes so that we could administer the federal program.
This is fascinating. I'm just wondering, what is the average age when the names are actually given to children in the tribe tradition?
Well, you have a couple small children. Would you trust either of them to name themselves?
No, I think no. I think like their names would be related to some fascinating, fantasy at the age of 4, like policeman or some hero like Spider-Man. So I would wait for a couple of years more. Yeah.
But there are, so then, right, you just remember that native names are different. So, we have right, my indigenous and they don't all, this is a unique tradition to just one group of people in one part of the United States, and not everyone who is even a member of the tribe subscribes to this part of the native religion. But there are when Indians name themselves, and not necessarily naming themselves at birth or when they're 4, but we have the president for a long time of the Congress of American Indians was Wilma Mankiller, right? So it is, we have these names, and it's right. I've had students, only one name, no surname, whitefish woman, right? It's you names are different in indigenous cultures.
Yeah, so interesting, so different. Let's before opening the floor to the students, let's go into the case. So we have
sure. We can talk about the cases. This is one of the most controversial Indian law opinions that's been written, and so much has been cited about it because it's about the protection of culture versus the protection of gender.
Yeah,
and it's been cited, even outside the Indian law context by the court for what it says, about rights and civil rights and human rights. And so, I'll take any questions, comments, whatever you want to do. Let me know.
So maybe just a few. Oh yes, and Mariam, the student, actually, she actually gave us
yes, I actually asked not ChatGPT, but something like ChatGPT about that case, and it was not referred in the CHR practice and not cited ever, as I see, because actually it's not connected to the CHR practice at all. So it was logical that it was not.
It's connected to state practice in that the Santa Clara Pueblo are a state. And they are a recognized government that passes its own laws. And
like
right,
maybe,
but obviously they're not a European Union state, right? Like
margin of appreciation in that regard. I also draw a parallel from this like attitude towards Indian people and the United States, and like attitude between states and European Court of Human Rights Court, ECHR court, because ECHR sometimes grants the margin of appreciation of state. That means that some issues are in those sphere, and ECHR is not like as much able to decide when it's come to the state's margin of appreciation. But I really have one question, if I may ask.
Sure. Go ahead.
Yes, I mean, firstly, I draw that parallel, but in case of Indian people, indigenous people, I heard that they are not bound by the USA Constitution, like fully. And from the theoretical point of view, I somehow don't understand this concept, because state, from my perception, even in this federation or confederation, is when any entity agrees on the main law of the country, like on the constitution. And if these people does not agree on this main law, why are not they granted with independence, and why are they still considered as like part of the one state? From the constitutional perspective, how you would evaluate this relationship?
So, no one asked in the 1700s, no one asked Indians to join the Constitution, and I don't know that they necessarily would. More indigenous people fought on the side of the British in the Revolutionary War, although there were certainly some tribes that joined on the side of the US. But this idea that we agree to be bound, or that you need to agree to be bound for rights to attach, and that isn't true with our like indigenous communities, in that they are our states, but they are not foreign states. So we have this really kind of crazy case, Cherokee Nation v. Georgia, in the 1830s, that decided that tribes were a domestic dependent nation. And so they are not allowed to have their own armies. They can't have their own external relations. So they can't seek a seat at the UN, right, as a sovereign. They can't sign a treaty with Mexico or Canada. Their foreign policy has been ceded to the federal government, even though they are not otherwise bound by the rights created by the federal government. And the Supreme Court justified this as the right answer by going back to this thing called the doctrine of discovery, which, depending on how much you've been paying attention in this area, we just had the Pope just finally renounced the doctrine after several centuries. But it's this papal doctrine that comes from Europe. And when back in the 1400s, when new worlds were being discovered, the Pope declared that by virtue of bringing Christianity and civilization to indigenous peoples around the world, the Christian nations of Europe could claim the ultimate right over the land and its people, as if it was a bargained for exchange. And of course, indigenous peoples never bargained for this exchange and would object upriously to the imposition of it, right, for centuries. But this doctrine of discovery was papal law, was civil law in Europe and common law in the UK. And we took it into our own legal system in a series of early cases in the 1800s that found that by virtue of being discovered, Indians had lost this kind of sovereign right to object. Wow. And that's still the law today. The doctrine of discovery I mean, there are whole books on it, right? And not just in the US, the doctrine comes from canonical papal law. It comes from Italian civil law that was taken into US or British common law and then taken into American common law.
Very interesting. Yeah, thank you. Kirill, go ahead.
Yes, first of all, I wanted to say that it is a very interesting question, a very interesting case regarding these Indian tribes. And while reading this case, I had a question. What is the role of, for example, advocacy groups and civil rights organizations in protecting the civil rights of Indian tribes? And how can, for example, these groups work effectively with, you can say, tribal governments and federal agencies to address civil rights violations? What can you say about that?
So I would say that we have dueling civil rights groups here, because there are Indian civil rights groups that like this outcome, right? That want tribes to be exempt from these rules and capable of deciding rules on their own. And as the material gives just a little bit of context, right? This right that Ms. Martinez is asserting, we have this thing called the Indian Civil Rights Act, right, from 1968. So the at some point in the 1960s, the senator from North Carolina discovered magically the Constitution didn't apply to Indian tribes. So he wrote a law. And the original law, the Indian Civil Rights Act, in its original draft was just to apply the entire Constitution to Indian tribes. And Indians objected, and so did a bunch of other people, because that would mean that Indians had the right to bear arms, and not everyone was comfortable with Indians having a right to bear arms. But but it would also do things like freedom of religion. And a bunch of tribal governments are religiously based, like there are theocracy governments in the US. And so, they fought to remove a bunch of those rights. So now the Indian Civil Rights Act doesn't give, when it was passed, it didn't give all the rights of the Constitution. It enumerated these rights. So there are lots of rights that are missing. For example, the right to counsel. When you come even to my tribal court, in a criminal case in which you could be imprisoned, you do not have the right to an attorney. You can bring an attorney with you, but you do not have the right to an attorney. Tribes do not have the right to bear arms was not given. The freedom from the establishment of religion was exempted. The right to a republican form of government was omitted, right? So there are rights groups that argue that these rights should also be protected by tribal governments, right? And so they're out there advocating either tribal governments to adopt these rights or for the federal government to enforce them through an expanded version of the Indian Civil Rights Act. And there are advocates for tribes from the civil rights perspective that are arguing for fewer of these requirements and restrictions, that tribes should be able to determine for themselves what rights to extend when you are in a tribal court or when there is a tribal government. So none of this means, like, if you're an indigenous person and you're in a state court in Florida or New York, you are also a US citizen and you have all of the rights that are there. The limitation is only when it's the tribal government that acts. And so, to be completely honest, there are fewer civil rights groups who care that much, right? Because it's a little bit hard. If you're a civil rights advocate, aren't you also an advocate for tribal sovereignty? And if you're an advocate for tribal sovereignty, what does that say, right, about when tribes use their sovereignty to do illiberal things? How do you advocate, right? Like, you want tribal sovereignty, but you also want liberalism. And those are at odds with one another.
Yes, so we go into opposite directions, actually in some cases, yeah, it seems. Oh.
And the rights groups do too. They splinter, right? Some rights groups will put sovereignty first and some right groups will put liberalism first, and they advocate accordingly. And you get competing amicus briefs, and you get competing cases at the court. Yeah.
Wow. Thank you. Anna, please.
Yeah, I just want to ask two short questions. Firstly, which sources are valuable and credible for the tribe's courts? And the second question, based on this decision in this case, I would like to ask how we can say the correlation between this tribal sovereignty and the possibility of the state actually to interfere into this tribal sovereignty with the aim, for instance, to protect the human rights of these indigenous people. So as I understood, the United States took the position that in this particular situation, the prevalence will be given to this cultural rights and that this within the discretion of the tribes. I'm correct, yeah?
Yes. Yeah, Ms. Martinez was not able to enroll her children, even though her brother, who, if he had married a woman outside of the tribe, would be able to enroll his children. This is textbook gender discrimination, right? You don't, I mean, it's textbook gender discrimination. Men who marry outside the tribe may enroll their children. Women who marry outside their tribe may not enroll their children. There's no other way to look at it than it's an example of gender discrimination. So in response to your first question, the authority of tribal so we have our own, our series of tribal law, right? So we have tribal courts, they have their own tribal court opinions. Those tribal court opinions form the basis of, the tribe's law. And we have good legislative history. It's documented from council why they've adopted certain ordinances, and we have traditional practice. So if we need to, we can bring in and ask elders of the community what the traditional practice is or was and why it's there, right? And so we can make arguments based on those sources of law. When it comes to the federal government, the Supreme Court here thinks that Congress walked the line the right way. So it says, look, there are these rights, and Ms. Martinez, these rights that are supposed to be protected. And the Indian Civil Rights Act includes equal protection, right? You cannot discriminate on the basis of gender. But the only remedy it gives is habeas corpus. And so I would assume that habeas works in the civil law or Lithuanian system, right? So a habeas writ, if you think that you've been incarcerated wrongfully, habeas corpus in Latin just literally means produce the body or bring forth the body. It allows someone to argue to a court why they should be released or freed. And so here we get a situation where we have a legislative mechanism. We have a right without a remedy. Ms. Martinez has the clearly established right to the equal protection of laws. But the only remedy she has is habeas corpus. And since she has not been locked up because the tribe won't enroll her daughter, she has no remedy in the judicial systems of the United States. She has the right not to be discriminated against, but no court in the United States can give her the remedy when the tribe discriminates against her. And that is a really difficult thing for my students in the US too, that you can have these, doesn't the right imply the remedy? And here the court says, no, we are going to require tribes to give or protect these rights. But if they don't do that, we will only intervene if someone's liberty is jeopardized. Otherwise, it's up to the tribal court to do the right thing. And in this case, the tribe just denied Ms. Martinez the right to enroll her children. And if you read the notes afterwards, you'll understand why. That Santa Clara is established as a moiety, that the people are either summer or winter people, and you have responsibilities to your community based on your moiety, whether you're a summer or winter person, and you inherit your moiety patrilineally. You inherit it from your father. So men can give their children, even if their wives or girlfriends are not members of the community, they can give their children their moiety because it's inherited from the male side. But when a tribal member marries a man outside, that man doesn't have a moiety, right? I mean, he's not a member of the community. So his children can't inherit their responsibilities and so therefore are excluded from membership. And the Supreme Court says that's something that only the tribe can fix.
Sorry, I just wanted to add to my question. So do these people have a right to apply to Inter-American Court of Human Rights? So like to seek the protection under the international level if the United States don't provide any remedy?
Although the United States is a signatory to the Inter-American, to the treaty, it is not a signatory to the court. So, right, again, we have a handful of cases not involving Ms. Martinez. The most famous, the Inter-American Court case came out of Nevada when the government came and seized a bunch of horses from a Shoshone Indian and then didn't feed or water them and allowed the entire herd to die. And then they brought a claim in the US courts, which was denied. And they brought a claim at the Inter-American Court and they won. And they tried to enforce it in the US, and our US Supreme Court said the Inter-American Court has no jurisdiction here, and our courts are not open to enforce its judgments. And so after that, there is no right, like there is no right to enforce the judgments in that way. And I mean, to be fair, Native people, as like, it's hard when you come at these questions as a community of non-Indigenous persons. You look at that through the lens of these Western rights. But if you keep reading in the materials, you get, you know, under the discussion of feminism, you get the discussion of a very different set of understandings between Native female legal scholars and feminist legal scholars. Feminist legal scholars like Judith Resnick is cited here. She is the federal courts person at Yale Law School, right? And she's just as a tragedy, right? Like this is a clear violation of our understanding of rights. And then you go down and you see, right, the Native female lawyers, right? You know, a bunch of them on page 392 in the material, right? And it's right, you get Eva Petrovsky, right, who's a Michigan tribal member. I like the Martinez case. I can tell you right now, I think that even though the comment in the McKinnon article was that the only time the Supreme Court upheld sovereignty was at the expense of an Indian woman, and I would say I would pay that price. I would pay that price. I would pay that price because I know a different world. I don't really have a life without the tribe's sovereignty. We don't have our land without the tribe's sovereignty. We don't have much hope of preserving our language. We don't have much hope of being able to live at home and raise our children where they can know about who they are. And you get these Native female scholars that say, yes, take away my equal protection right. In exchange for tribal sovereignty, I will talk to my tribe and I will lobby them to change their law. But until they decide to change, the federal government shouldn't force me to. And I will choose culture over equal protection, right? Even though that means that I am discriminated against. And it's not a one-off opinion, right? The Conference of Native Female Scholars, not a single one wanted to overturn the Martinez case. And yet a conference of feminist scholars, all of them would want to overturn the Martinez case, right?
Yeah, thank you. Yeah, Bogdan.
Thank you.
Thank you, Bogdan. Please go ahead.
Yeah, thank you very much. Short comment and one question. So before your presentation, my thoughts was that European continent's justice system is very complicated, but it's no more complicated. I mean, the European Court of Human Rights, European Court of Justice, and other national courts, of course, in situation with your examples is much more complicated. And my question actually was related to a little of the question of Anna asked. So what are real international protection mechanism have the indigenous people? Of course, some UN forum or another instruments are present, and we can find information about that. But what's actually how these people can protect their rights if the national and state and federal system are not functioning in proper way to protect their rights?
Well, first I want to say I like the flag behind you, right? But this idea, it almost sounds like you're starting from the perspective that Ms. Martinez's rights were discriminated against. And that is not an indigenous perspective of the law, right? An indigenous perspective of the law is that there shouldn't be any other mechanism that can tell the tribal government to force it to change indigenous culture, right? And so external mechanisms that would allow that to happen would be bad from an indigenous rights perspective. But okay, that aside, these mechanisms do exist, right? So at the UN, we have the UN Declaration on the Rights of Indigenous Persons, which has the unfortunate acronym of UNDRIP. And there are, right, although it is a declaration, certain nation states have made it binding law, right? Mostly Central and South American states that have said the declaration is essentially binding customary law. The US is definitely not going to go there, but right, there are, from indigenous persons in general, right, there is this declaration, and the declaration includes protections for the right to culture. And so, right, the declaration is in that point at odds on, right, the UN Convention on the Rights of Women, right? I mean, it is, in that sense, right, you have a cultural right and a separate UN obligation to treat gender equally. And there are, even within the international system, these tensions. Outside of the UN mechanism, some of the most important, indigenous rights bodies, the International Labor Organization, or ILO, ILO 167 is the right of, or is the ILO Convention on Indigenous Persons. Right, what the UN Convention on the Elimination of Racial Discrimination, CERD, right, has protections or some provisions in there that relate to indigenous persons, and of course our regional bodies like the Inter-American Commission or the European Court of Human Rights. All of which provide avenues, and all of which have good examples of cases, right, where indigenous peoples bring them in order to try to kind of move their rights forward. But to go back and to circle back to the core of the question, it really is that assumption that what's going on here is a violation of Ms. Martinez's rights. And she's been discriminated against on the basis of her gender. She's not allowed to enroll her daughter. But I think from an indigenous perspective, they wouldn't want anyone to be able to overcome that, right? Like, that is the right answer from an indigenous perspective, is to work within the tribal community and get the tribe to change its own culture. Because of course, culture is malleable, right? Culture changes over time. Look at even, our acceptance of LGBT rights, for example, right? Where we were, 50 years ago and 20 years ago and today. And that's an evolving societal standard, right, in different parts of the West. So one of the things I will tell you that's not here in the reading is that in 2014, the Santa Clara Pueblo tribe had an election on this issue. And 2/3 of tribal members voted to change the enrollment criteria to allow female members to enroll their children and to take their mother's moiety instead of their father, right, in create an exception to take their mother's moiety at the time of their enrollment. And so it did take 40 years, but advocates would say this is how it was supposed to work. You talk to the tribe and you had tribal members themselves advocate on behalf of the female members, and the tribe had an election and decided to change its ordinance, rather than being told by an outside entity, whether it be a federal government or an international body or a court, that, right, you can change the culture and change the rights internally. And it took longer, but right now, Ms. Martinez is able to enroll her daughter, Abigail. She's in her 40s, but she's able to be enrolled.
Interesting.
Thanks a lot.
Thank you. Yeah, Divya, please.
First of all, I would like to thank you for this interesting topic because I myself am part of one of the indigenous groups in India, one of the 705 ethnic groups actually. And I completely relate with the case that we were given to read before the lecture, because in India, for the tribal women to get property rights, it was a big issue. It still is a big issue. It's ongoing matter in the Supreme Court of India. And I happened to work and write a paper on the rights of the indigenous women who were being denied the right to property if they married somebody from outside the tribe. Mm-hmm. So I completely, I can really understand the conflict that comes when, the general law tells you that, there is right to equality for women and men equally to get the property of the parents. And on one side, there is a civil group made of the tribal women of my state itself, who are working relentlessly for over 10 years or 15 years and still fighting that case against the same people of the community who are not ready for the change yet. And for now, the matter has reached the Supreme Court in 2022. There was a positive outcome, but yet there is, when it comes
good
to
luck enforcing it at the local level, right?
Exactly. Yeah. And currently the group, the civil movement group, is planning to meet with the president, who also happens to be a woman of a tribal community. So I don't know how it's going to pan out, but it's really interesting for me, and I completely understand. And I don't know, maybe you understand it so well. For somebody who belongs to, a community like that, where customs and your traditions are so important, and one side you are a legal, student, you're understanding the whole concept of equality, and you feel it in your neighborhood, in your, community itself. You see people who actually are being deprived because of this. There are women who don't even want to get married at all because of these, customary laws. So in your opinion, what do you think is the best way to deal with it? I completely agree that the community itself has to be the game changer in this situation. But otherwise, anything else that you would like to, add on?
Yeah, I think you speak of something that we see all the time in indigenous community, that you can win at the court and still on the ground. Like the life on the ground doesn't change until minds change, right? And so since that's true, the approach that the court takes in Santa Clara Pueblo seems to be, right, one that allows, like, instead of having this kind of top-down approach that says the government now comes in and tells you it must be this way. And then there's people who will then become immediately resistant to it because it's the government telling you to do it. Even though if you were to talk to them one-on-one, you could change their minds. When the government was separate, you say, look, do we really want our women treated this way? Right? Aren't they part of our community? Isn't there a way for us to, adopt their husbands into our community, so it's not like they're marrying out, right? It is a different kind of, and that also was considered at the Pueblo, right? Is to adopt, to have women have their husbands adopted in, and through the process of adoption, the husband would obtain a moiety, and then the moiety could be inherited patrilineally still, right, by, but through the process of adoption. And the tribe itself decided, right, that it would be better to allow the children to inherit their moieties from their mother rather than to adopt all of their fathers, right, from a cultural perspective. But isn't it better to have the tribe make that decision? Like, universal rights give us an end goal, right? The idea that we shouldn't discriminate based on gender should be everyone's end goal. But how do we get there? And when the federal government tells you how to get there, that becomes more problematic because there's some immediate resistance to implementing that decision. Whereas when the government can provide a space for the conversation, and you can change minds, and you can say, all right, well, we need to get there. How can we culturally get there? Then the community can make the decision on, for example, do we adopt in the husbands and allow moieties to be inherited patrilineally? Or do we leave the husbands outside the community and allow the children to inherit their mother's moiety? That's a cultural decision that no court should make. And the problem is that it takes time. And that the larger your community is, maybe the more time it takes. Because we're talking in Santa Clara Pueblo, we're talking about a community that numbers in the thousands. Not even the tens of thousands, the thousands, right? You have to change 3,000 minds and you can fix this problem. In some of the states that you're talking about, and in some of our larger tribes, we are talking about hundreds of thousands of persons. And in your case, you may be talking in India of millions of persons whose minds must need to be changed. And that's a bigger project, right? So all of that kind of scale and scope is difficult to put together. But my instinct in working in this area for more than 20 years and serving as a judge and serving as a, right, is that it's better if we can create a space to allow the communities to work out how to get to those universal rights. And the problem is that in giving them that space and that time, there will be years, decades, where the discrimination continues. And the only kind of comfort that I have is that if the government mandates it, the discrimination on the ground will probably continue anyway. And so, right, allowing the organic process is a better, longer term solution. But it's so hard, right? I mean, it really is.
Yeah, I totally understand. Thank you.
Yeah, thank you. And then the last short comment or question, Mariam, and then we will end.
Yes, I have a question. As Mr. Grant said, Indian people actually are bound under the Indian Civil Rights Act, and they are entitled with this right to equality, but they actually have not remedy. And what do you think about the case of Marbury versus Madison? Because that case also was about the situation when a right actually existed, but there was no remedy. And because of that, Justice Marshall declared constitutional norm void. And what do you think, I mean, from the legal perspective? I understand that from the political perspective, you prefer these indigenous people to change by themselves their attitude. But from the legal perspective, what do you think about possibility of using that precedent, Marbury versus Madison, in this case, when actually right exists, but we have no remedy?
Well, I mean, although the court isn't citing Marbury here, that is essentially what it is doing, right? Is that the Santa Clara Pueblo opinion is more an opinion about the powers of the federal court than it is an opinion about the rights of the Santa Clara Pueblo. And the opinion ends up saying, you have these rights under the Indian Civil Rights Act, but the only remedy Congress has allowed the courts to give you is habeas, because the right comes in section 1302, the right to equal protection of laws, due process. But the remedy provision is in section 1303. And they only, right, Ms. Martinez was asking the court to create a common law remedy, to create a remedy that Congress didn't imagine. Because a right existed, so she argued a remedy must also exist. And she won below, right? Our appellate court upheld that principle and created that right for her. And so one of the reasons the Supreme Court took the case and reversed is because it felt that the lower court exceeded its boundaries, not as it comes to equal protection and due process, but exceeded its boundaries as it comes to the jurisdiction of federal courts in general. And saying, essentially, Congress gave these rights, but then limited their enforcement in our courts only to habeas corpus. And since Ms. Martinez was not incarcerated, her liberty wasn't confined, there is no remedy the federal courts can give, which is exactly the outcome that happened in Marshall, right, or in Madison, in Marbury versus Madison, that Marbury was entitled to his commission, but the courts could not force it to be delivered, right? It was up to the executive branch to deliver it. And if Madison wasn't going to deliver it, he wasn't going to deliver it. And that created an implied limitation on the courts that we have seen, kind of traced in US legal jurisprudence a long time. And Santa Clara Pueblo fits into that world. It fits into the world of here you have a right, but there is no express remedy.
Okay, thank you so much, and thank you everyone for really great questions, and thank you for such a fascinating response of Professor Christensen. I really enjoyed. I think everyone really enjoyed your thoughts, insights, and I hope we will be able to do something similar someday in the future. So thank you so much.
Well, yeah. Thank you so much for having me. I appreciate it.
Yeah, thank you. Great.